Okay, sorry about that interruption. Now, welcome back. We are looking at the Law Succession Act, and we were explaining about testamentary freedom that any person of sound mind, okay, any person of sound mind and who is an adult has the freedom to make a will and to sign a will, okay, and that the court does not try to remake the will, only to interpret it so that the intentions of the deceased are well understood and implemented. Now we say that a person has to be of sound mind, and there's a presumption that he was, unless when he was signing the will, there is proof that he was not okay, that he was maybe delusional or mentally uh, exhibiting symptoms of, mental disturbance or incapacity, drunkenness, or any illness which might have uh, caused some problem with his mind. We said the case that that was held by the Queen's Bench was the Banks versus Goodfellow, where it was held that a person must have a sound mind and memory while he is making the will, and he must also understand what he is doing or saying and the consequence of his uh, his will. Okay, he must also be aware, like remember the property that he is bequeathing, okay, and the people and his relationship with them. All right. Now that is Banks versus Goodfellow. Then we had a case of Vijay Chand, Lakan, Shah versus Public Trustee. This is a Nairobi Court of Appeal civil case where it was held that the deceased was very sick from syphilis and diabetes when he executed his will, but it was held on evidence that he executed the same during a lucid moment. So we can see that even if someone was mentally incapacitated, but during the time he signed the will, he had improved significantly, or he was in good mental state, then the will be declared valid. Sometimes people just want a reason to invalidate a will. Maybe they are not happy with the allocations they have been, the bequeathments they have been given. Maybe they think someone got more, or they think that they shouldn't, the disease shouldn't have bequeathed someone, So because of that, they try to find reasons. Maybe they'll cite an illness. They will try and give reasons like excuses, find some loopholes, But most of the time, the court will just look at the time of execution and see whether when he was signing that will he was okay or not. The burden of proof that a testator did not have a sound mind, of course, shall fall upon the one who alleges that. Whoever alleges must prove that is the law. So there's a case of Broughton versus Knight. Broughton versus Knight. I don't know if I'm this correctly pronounced. That is where the court held that the testator has has to have a memory to recall the people he is bequeathing and understand to comprehend the relationship with them. Okay. Then so the circumstances of the making of the will are very important. Okay. He must have a sound mind. He must understand the nature of the business of making a will and the consequences. If he doesn't understand what he is doing, then it doesn't make any sense. Okay, in Harwood versus Baker, that is an 1840 case. I don't know why these cases are so old. A testator executed his will on his deathbed and left all his estate to his second wife, to the exclusion of other families. So you can see another scenario here. He was at the time suffering from a disease that affected his brain, so he was not mentally sound. Okay. It was held that based on the evidence, he did not have a sufficient recollection, so he might have forgotten his family, his other family members. At common law, the burden of proving testamentary capacity is on the executor. If the event of the validity of a will is questioned or contested on grounds of incapacity, the executor must prove that at the time the will was made, the testator was having a lucid moment and that his mind was sufficiently clear about what he was doing. However, this goes against the act because in the act, the burden of proving that a testator was not of some money shall be upon the person who alleges. So this is incorrect in law because it's not supposed to be the executor who proves that the person was mentally okay. Okay, but it is it is the person who alleges that the deceased was not well. Why would they confuse such an important fact? I don't know. Section 5(3) of the Law of Succession Act creates the presumption that a person is making a will is of sound mind unless the contrary is proved. Now, in the matter of the estate of James Ngegi Muigai, that is an 1896 case. The testator was dementing and physically incapacitated due to joint pains and hypertension. When he made the witnesses who attested the will testified that the deceased looked normal, the court was satisfied that he was of sound mind, as the objectors had failed to prove unsoundness. So you see, the person who objects to the soundness is the one who has to prove. So this is correct in law. Then we have the case of Mbogua versus Mbogua, where it was emphasized that a testator must be of sound mind and he must not, at the time of giving his instructions, be drunk, insane, or otherwise incapable. Okay. In John Kinuthia, Kithinji, and Kithua Kiarie, I would hardly remember these names, but let's just learn the ratio decidendi. Now, the deceased was admitted in hospital, seriously ill with cancer of the duodenum, sent for her advocate, whom she gave instructions to draw a will, the details of which comprised of how she wished her property to be disposed. The advocate drew the will and explained its context in the presence of a nurse. At the time of execution, she was said to be mentally alert and understood the advocate's explanations. Consciously and knowing what she was doing, that she executed the will. It was held that in the absence of evidence that the illness had affected her mind so as not to know what she was doing, when she signed the will, the subject was valid. So also in this case, whoever tried to discredit the will failed. Most of the times the people who discredit wills, they don't come from a good place. Just so to say. Because remember, the deceased knew what he was doing, okay, when he is dying. Death is serious. There's no way you can just contemplate death and then do some haphazard things. Death is serious, man. Okay, so we have another case here of insane delusions. Insane delusions. This is when I say delusional. Yeah, so where there are delusions, you would need to see whether the understanding was impaired or not. So it says that it's not a prima facie, evidence of invalidity of the will, unless you can prove that the delusions affected his understanding. Approach of the courts and same delusions differs depending on the impact of delusion. So we have the case of Dew versus Clark. Let's just define delusions, because if it's different from other types of mental incapacity, it's important to understand what is different about it. Delusions. Delusions are defined as fixed, false beliefs that conflict with reality. So it is fixed and false beliefs. Despite contrary evidence, a person in a delusional state can't let go of this conviction. Delusions are often reinforced by the misrepresentation of events. Okay, then they also involve paranoia. So, like for example, when someone says someone is always watching them, trying to kill them, or maybe someone is telling them that they will die. I don't know, but I'm getting it's more of the state of your brain And you know how when you have those, when you're struggling with mental health and you start maybe hearing voices, or maybe you start seeing things, or you start believing in certain things that are not real, like when you see money flying, like, or maybe you just have a sense that someone is always watching you wherever you are, something like that. So, and or maybe you believe that there are spirits who are with you maybe every day and they visit you maybe at night, and if someone were to tell you no, that's not the case, and prove to you there's no such thing, you couldn't let go of these beliefs. You would say, no, I know and I am sure that whenever I go to sleep, spirits come to me and they show me these, beautiful places. You know, I don't know really. It's kind of, I really don't know, man. Like these delusions control you, like you are 100% sure they are real and they run you, they control you, they tell you, you know, how to react, how to act, and you are scared. And they have like some scared element in them, like for example, where you believe that someone is out to kill you, someone is going to break into your house, so you spend so much money buying like 10 padlocks to, secure your home from every area. You don't open the windows, you are scared. I really don't understand, but it has something to do with that, the level of paranoia and false beliefs that you keep believing as to be true regardless of proof. So this case that is I have seen is the case of Dew versus Clark. A person suffers from an insane delusion if he holds a belief of a particular matter which no rational person could hold, and the belief cannot be removed from his mind through reasoning. For example, where one thinks or believes that he is being bewitched. So, where, for example, in Dew versus Clark, they define what delusions are, and these are beliefs no person in their rational mind could think, where the person feels that he is being bewitched. Okay. Then we have Broughton versus Knight, the case we just saw just a few minutes ago, where the members of the jury asked themselves, can I understand how any man in possession of these senses could have believed such and such a thing? If the answer you give I cannot understand, then it is the necessity of the case that you should say that the man is not sane. Okay. So Broughton, you said, was the case where he had to have, the court said that you must have memory and an understanding of the nature of the thing you are doing, the nature of wills, and the relationship you have with them, yeah, the people you are giving the property. So there's this case of Vahela versus Vahela, 1999 case, East African, Tanzania, where it was held that for delusions to be material, there must be a connection between the will and the delusions, the poisoning of affections and the perversion of the sense of right, while in Dew versus Clark, the testator made a will which was rational superficially, but which excluded his daughter from the benefits. The daughter showed by way of evidence that the testator had an insane aversion of her. He had refused to see her face for the first 3 years of her life, and he had made her sleep with an insane woman. Okay. Then we have another case of Ree versus Nightingale, 1974. Lack of mental capacity was shown when a son was excluded from his father's will because the father wrongly and insanely believed the son was trying to kill him. Okay, and then Banks versus Goodfellow, we say was that where they held the person must have a sound mind and memory and understand the nature of his events. So the testator believed that evil spirits and a person who was already dead were pursuing him. So this is a classic case of paranoia, and we say delusions are like they make someone paranoid. So you can see here. You can see that he saw spirits and a dead woman following him, chasing him. But you see, even though the delusions were there, they didn't affect his understanding of the property and his will, his the people he wishes to bequeath. So he understood the transaction. Okay. So the will was valid. So that is why I'm saying here that its delusions are not automatic conclusion of invalidation. If it can be proven that the delusions did not affect the mind, then there is no reason to invalidate the will. If the delusions didn't take away his understanding of what he was doing, we have another case of Free Bowman. Free Bowman's estate, 1938, England reports. All England reports. So, as testator made 3 codicils. Codicils, we define them and say they are codicils. What do you call them? They are documents that you use to alter a will or add something to a will. So that is what a codicil is. Okay. So he made 3 codicils bequeathing his properties to charities. He later began to suffer from an insane delusion that the county council was persecuting him. The insane belief arose out of the council's attempt to acquire part of his land to build a hospital on it. As a result, the solicitor executed a whole codice, of which one clause provided that all reference to English charity should be read as referring to corresponding American charities. Probate was granted of the will and the four codices, excluding only the clause in the fourth codice on the American charities, which was declared invalid for lack of testamentary capacity. So the other codices were valid except for the fourth one, which where the clause that said all the charities that previously were English in the will are now to be American now. So those are the important cases on soundness of mind. Dew versus Clark. I'm interested because this case I have seen it. I have seen it so many times. Let me just get the facts in brief. Excuse me. Okay, so a father believed that his daughter was the devil incarnate and disinherited her in his will of 1818. After the father's death, evidence presented by the daughter showed that she was well known for her good disposition and that her father had falsely told others that he lavished his daughter with praise and wealth. The probate court found that the father's mindset when he made the 1818 will was normal in all respects, except toward his daughter. The court found that his thoughts about her did and could only proceed from and be founded in insanity, a partial insanity that only extended to his thoughts about his daughter and caused him to disinherit her. The court said that this delusion caused the will to fail. So the delusion is against the daughter and he disinherited her, making the will invalid. So then we have Vahela versus Vahela. The appellant was the elder Uttar, brother of the respondent, half brother. The respondent was granted probate of the will of the deceased, who was the mother of the parties. In her will, the deceased named the respondent as the sole beneficiary of certain house. The respondent stated to be confirmed as administrator of the estate in the terms of the will of the deceased. Prior to the last will executed on her sick bed, the deceased had executed a previous will in which the said property was to be shared equally between them, the brothers. The respondent therefore contested the grant of probate in terms of subsequent will, alleging that his mother was physically and mentally incapacitated at the time she purported to make the will, The respondent laid evidence from the physician who treated the deceased, who stated that the patient was physically and mentally incapacitated and gave reason that she was conscious but confused and refused medication and too sick to work on any document. Uh, the appellant laid evidence from himself, the lawyer who drew the will, and the persons who witnessed tended to show that the deceased had been compos mentis at the time she gave instructions and she executed. After judgment was given in favor of the respondent, the appellant sought a fresh reconsideration of the evidence on appeal. It was held the validity of appeal derives from testamentary capacity and from circumstances. The legislator must understand the nature of the act and its effects and the extent of the property he is disposing. So you must understand the nature of the act and effects and extent of property. Understand? Yeah. And that no disorder of mind shall poison his affections, pervert his sense, or prevent exercise of his duty. So you can see all the cases I have told you, they are well summarized. So Doe versus Clark, you can say, is the captain of insane delusions as far as the dad believed that his own daughter was the devil himself, okay? So you can imagine how that can turn out to be, given that you have tried to show the court that your own dad was not okay when he made that will because he treated you like the devil. Okay. So now these cases are good to know the facts because if you understand, you can apply them very well to different case scenarios. If you just look at the whole thing, doesn't make sense. You can just lose, So let's just look at a sample will. Let's just look at a sample will. Okay, so we have a sample will, last will and testament of Mr. Wade. This is Yeah, so last will and testament of Mr. Limo. I, Limo, Post Office Box number this and ID number this in the Republic of Kenya. Number 1, I revoke all previous wills and testamentary dispositions, if any, made by me, insofar as they relate to my estate, and wish this to be governed by the laws of Kenya, and declare that I am domiciled in Kenya. I appoint as my executors and trustees Mr. Mzuri Limo of PO Box, Nairobi in the Republic of Kenya, and Mr. Mwaminifu Limo, Nairobi in the Republic of Kenya, herein after referred as to my trustees. I devise and bequeath to my trustees the entire residue of the property owned by me at my death, real and personal, wherever situate. I direct that my trustee shall pay all my debts and expenses of my last illness, funeral, burial as soon after my death as may be reasonably convenient, and that they shall settle and discharge in their absolute discretion any claims made against my estate. I give and bequeath the following legacies free of duty and taxes. So gifts are not taxable, are not taxed. Yeah, yeah, okay. So I give and bequeath the following legacies free of duty to my wife Nara Limo, ID number so and so, a matrimonial home in Fair Acres, Karen, situated on LR number this, Karen, all my shares in Jadiri Investment Company, as well as all my properties in Umoja Place, LRA. These are parcels of land, like 4 of them. To my son Choto Limo, my farm in Kiambu, LR number 234678, Kiambu, and my rental apartments, Jadiri Heights in Lavington, LR number these days. To my son Kali Limo, in equal portions of all my insurance policies of Jijeng Insurance Company Limited and of Oz Insurance Company. To my uncle Tuzo Limo, my share and reference number this, Yaya Trans. I direct that upon my death, my body shall be buried in my Siaya farm next to the burial site of my parents. This shall be my final resting place. In all the clauses of this, my will, the expression my trustees shall mean the persons who, either by virtue of appointment, I herein before, otherwise shall be from time to time the executors. In witness whereof I, Limo, the testator, sign my name to this instrument consisting of 3 pages, this day of this, and being first duly sworn, do hereby declare to the undersigned authority that I stand and execute this instrument my last will, and I will sign it willingly, and I execute it as my free and voluntary act for the purpose expressed in it, that I am an adult of sound mind and under no constraint or undue influence. Then we have the section for witness. We, Naralimo, Chotolimo, Kalamualabu, and Ibrahim Ondieki, the witnesses, sign our names. We have like 4 of them to this document, to this instrument. But you see here we have a problem because I think this sample will has some issues because Yeah, so this is like a question scenario. There are so many things that are wrong with this sample will, and you're supposed to you're supposed to say what's wrong with it. Yeah. So as I was reading, I realized, because if I remember correctly, beneficiaries cannot be witnesses. If I'm not right, if I'm not wrong. Let's just look at the how this question, how, I mean, what problems the will has. Okay, so let's look at what is wrong with this will now. The Black's Law Dictionary defines succession as the fact of the transmission of rights, estate obligations, and charges of a deceased to his heirs. Yeah, this is just general. So the first question or determination is as to validity. And when we talk of validity, the first thing is to talk about the capacity of the testator. Okay, the age, capacity means age, means mental or mental incapacity, which we looked at all the cases. Yeah, what they say, Dew versus Clark, Fahela versus Fahela, Banks versus Goodfellow. All right. Okay. Now, was Mr. Limo of age of majority? Yes, he was an adult. Was he of mental capacity? So we are told here that Mr. Limo believed he was being molested by his old friend and that evil spirits had been pursuing. When you hear spirits, just know it's Dew versus Clark, the scenario where it's Dew versus Clark and Banks versus Goodfellow. But you would use Dew versus Clark to invalidate, and Banks versus Goodfellow was you would use it to validate. So that is like the opposites. You would use Dew versus Clark to invalidate. You would use Banks versus Goodfellow to say despite the evil spirits pursuing, the testator suffered from the delusion, yes, excuse me, but it did not affect his capacity or his understanding. When he was making the will, he knew the people, the relationship with him, he knew what his property, he recalled his property, okay? He understood the nature of the business he was doing, that he was leaving behind a will to show how his property would develop or would be shared among his survivors. Alright, so that is the difference. You would use do versus Clark where you want to say no, there's no way, no valid. But you would use Banks to say despite the fact that he was, it didn't affect, his ability, his capacity to make the will. So let's just move on. It says that Mr. Limo said he was being chased by evil spirits, so that falls under the radar of Banks versus Goodfellow. Alright. Okay, so you can see this. And he was therefore laboring under an insane delusion as it was defined in Dew versus Clark. Remember, Dew versus Clark defined the insane delusion, what it means. That is why it's such an important, it's a landmark case of delusions and how they can invalidate the will, where an insane delusion being a belief that no rational person would hold, that is what it means. So it's all about belief. And in Broughton versus Knight, it was also about belief. Can a person of reasonable mind believe such a thing? If the answer is no, then there is the existence of insane delusion. Okay, so we have that Dew versus Clark. Okay, so Dew versus Clark is the famous case here. Now, and in this case, Mr. Limo was also suffering from an insane delusion as to the definition in Dew versus Clark. Okay. Now, a person, okay. However, it was also held here that it is not fatal to the main testamentary capacity. It will only affect if it affects the way he disposes his property. Like in Dew versus Clark, we saw that while the dad was mentally okay, he had an insane delusion against his daughter, which led to him, okay, so he reacted and took action to exclude her, from his will. So that action he took is what invalidated the will. Now, if you are suffering from insane delusions, but during the making of the will, you understood the nature of the transaction you're doing, the business, the people, the property, you recalled, you understood. It didn't affect your decisions, okay? You gave whoever you needed to give. You thought of your dependents, the people who rely on you. You didn't do anything radical or drastic like in Dew versus Clark, Had the dad not done anything drastic, that will would be valid. So anything that is shocking, because being your daughter, you give all your family, you leave out a daughter who in 1818 especially, where would she go, That time in England, I think it was England. Is it England? I really don't know. But that time, 1818, come on. Well, how would a daughter survive when they were just simply not even allowed to work, There are no women rights and equality. She was, and she would need a dowry if she was to be married. Can you imagine how unfair that would have been, She couldn't work for herself. How would she eat? How would she drink? That was a crazy time to exist, So now, what else here? So you can see, even when you look at the questions in past papers, the notion of delusions has been coming up in the questions. The symptoms, talking to yourself, acting weird. So those things have been used. And I mean, to be honest, you would know at least which case to rely on if you wish to invalidate and if you wish to validate. So Dew versus Clark defines insane delusions, but says that unless it affects how he disposes the property. In Barnes versus Goodfellow, is the test for mental capacity he needs to understand. So there must be an understanding of the nature of his action, his what do you call it? His will. Excuse me. So he needs to recollect. So you need to not just start mentioning some imaginary property which you never had, So you need to have memory and understanding. And the people, you should know them, Like when you have dementia, for example, and you forget your own husband is your husband, or you forget your daughter, that you have a daughter or a son. So, and then you sit down to make a will in that situation when you hardly know the names of your son, that they are actually yours. Perhaps your mind tells you these are really nice people who have been looking after me, but I really don't know who they are, Or you know them 1 minute, then you don't know them the next. So in such a situation, obviously, the will is invalid. It can't proceed. So moving on. Banks, evil spirit. So then they used the case of Banks versus Goodfellow and said that therefore Mr. Limo had mental capacity as his delusion did not affect how he disposed of his property, and he met all the requirements as set out in Banks versus Goodfellow. Okay. All right. Now, attestation. The second component we need to consider is whether the will was properly executed. So we have a requirement here of attestation. Just a minute. So Yeah, so attestation and execution. When it comes to witnesses, Section 11 of the Law Succession Act provides that the testator's signature must be made in the presence of two witnesses. So the requirement is two witnesses. Mashahidi wawili. We just look at this section. Now, Section 11, as to witnesses, requires that the testator has to sign and affix his mark to the will, or it has been signed by some other person in the presence and by the direction of the testator. So to affix his mark can be maybe by way of thumbprint, or if he has a seal, that he's been writing letters with, I don't know. Now, the signature or mark or the signature of the person is so placed that it shall appear that it was indeed intended to give effect to the writing, and the will is attested by two or more competent witnesses, who each of whom must have seen the testator sign or affix his mark. So the witnesses must be present during the signing and affixation of the mark, have seen some other person sign the will on the direction presence of the testator. And each of the witnesses must sign the will in the presence of the testator. But it shall not be necessary that more than one witness be present at the same time, and no particular form of attestation shall be necessary. So the witnesses will sign, but it shall not be necessary that more than one witness be present at the same time, and no particular form of attestation shall be necessary. Okay. Now, let's just read here. We have a case of in the matter of the estate of James Ngedi Muigai. I can't remember this, but I really don't know. Mm, now, the law allows the will to be witnessed by two or more witnesses. Okay, but each should sign in the presence of the testator. The provision is unhelpfully drafted. It requires that the will be attested by two or more witnesses, each of whom must have seen the testator sign or affix his mark, and at the same time say that it shall not be necessary that more than one witness be there. I also thought the same thing. When you read this section 11c, you will question your understanding of English, because just look at this. It's a requirement that the witnesses have to be present and see the testator sign and affix his mark. Then it later says that it's not necessary that more than one witness be present at the same time, which is contradictory. Justice Comey said, who is, by the way, our Chief Justice currently. Is she though? Is she the same person? Yeah, let me just check. Justice Kenya. Yeah, she's called Martha Koome. Chief Justice of Kenya. Lady Justice Martha Koome is a human rights defender and a Kenyan advocate, born in 1960, went to Nairobi University. Okay, so she was, let me just see, she was a judge in High Court, I think. Is this High Court? Yeah, Nairobi High Court. So she has 33 years of experience in the legal profession. Wow. Wow. Oh. Oh. Okay, so Okay. So at least she noticed this contradiction in section 11C. You know, I don't know, but I'm not biased. I really passed succession while in college, and I really liked my succession lecturer, and I got a straight A without question, and I was motivated to read the act and everything. But that was it 2015 or 2014? A lot of time has passed, and I have seen other acts getting perfected, updated, with the current system. And this succession act somehow has been neglected as far as updates are concerned, because so much is not working. I think this act, you know, has some serious proofreading to be done, serious revision, but I don't know. It's even the section I had read, I think section 35, 35 in the beginning. It didn't make sense because I think there's an amendment that is supposed to bar women, you know, to bar someone who had a previous marriage in a monogamous regime, and if that person went ahead to marry someone else, it's not possible. So I don't know why the act still says in section 3.5 that it is possible. I don't understand some things, and that is why I think I am less excited overall to review this act, but I'm gonna try my best. Even the amendment of this section, that amendment was done like you can't, if you want to look at it, you wouldn't understand. So there's serious language here, communication problems in succession, and contradictions, and conflict of laws with other statutes that are more recent than this one, because this is Act number 8 of 1970. Wait, this is 1981, or just look at this. 1981, and we're in 2022. Oh my god. No, no, this is not, it's not fair to law students worldwide. Now, to taxation. Okay. So other problems which you would find in the Succession Act, if you are told to recommend anything, would be section 3.5 is contradicting, I think, the Marriage Act subsection there, which says that once someone marries under the monogamous regime, the man cannot go ahead and marry in any other polygamous regime, because that person will not be a valid wife. Okay, you understand? That is just not acceptable, at least according to the standards of drafting and and lawmaking. So let's just move on. Where are we? Okay, we have and then section 11 to section 11, that is subsection 5, section 11C, which says contradicting that the witnesses must be present, and then no, it's okay for only one. It requires that they will be attested by two, and at the same time say that shall not be necessary. Now, it is not conceivable how the witness can see the testator sign the will if both are not present at the same time, unless the will is signed twice by the testator. A will signed by one witness, as was the case in the matter of estate of Susan Canini Kilonzo. Susan Canini. Now, because of this section 11C, I will remember this case. Matter of estate of James Ngugi. James Ngenge, my guy. And sometimes if I can't remember, I just write the first name. But James is so common. Okay. So, a will signed by one witness, as was the case in the matter of estate of Susan Kanini, Nairobi High Court Succession Clause number of 2002, would be in contravention of section 11, and therefore null and void. To be present at a signing means the witnesses must be capable of seeing the testator sign. The witnessing is of the signature, that is the fact of signing. The witnesses need not look at the signature or even know that the document is away. Okay. The witnessing is of the signature, the fact of signing. Now, this was a case of Kanini Kilonzo. Kanini Kilonzo. So if it is signed by one, that's a problem also, because the Act in section 11 requires that so in Kanini Kilonzo, the will was signed by only one Shahidi witness, and that was not okay, because the minimum is the minimum of, excuse me, I need some support. Okay, the minimum is 2 witnesses. 2 or more witnesses, that is the minimum is 2. Excuse me. If the witness is present but unaware of what the testator is doing, the attestation will be invalid. Now, in Brown versus Skiro, testatrix took her will to her grocers to be executed. She asked two shop assistants to act as witnesses as she was signing. One of the assistants was busy serving a customer. The will was held invalid. People have creative ways of doing things. So recalling 1972, it was stated Obiter that if a witness left the room before the testator completed his signature, the attestation will also be invalidated. Okay, so you can see here you can see clearly that the whole purpose of a witness is to be present. Just be present and we see that sign, excuse me, just be present and be there when he is signing. Okay, so we hear here section 3.1, they are referring to section 3.1 that people who are strangers should not likely be chosen as witnesses, people who have no fixed address, people who can be far away who can likely be far away when the person dies, they cannot be traced. People who are minors, they cannot be witnesses. Drunks, insane people, blind and illiterate people. Okay, let me just say. We said a witness, we define a witness and say that, did we really define a witness? I'm not saying here. Yeah, he has to be of sound mind and full age. That is a competent witness. Sound mind, full age, just like the testator when he's making a will, is supposed to be of some and full age. So where a minor is a witness, it will not be okay. So executors can also sign wills as a witness. Now let's go to attestation. Section 11 provides that each witness must sign the will in the presence of the testator. They need not necessarily sign in the presence of each other. Now, attesting the will requires that the witnesses put their signatures in the will with the intention of validating the testator's signature. Okay. Now, so attesting the will requires that the witness put their signatures in the will, intending to validate the signature. And no particular form of attestation is necessary. The witness signatures may not be in a particular place, but should be so placed or present to show intention to ratify the testator's signature. We have a case of Biddle, 1974, England reports. Witnesses assigned the envelope containing a will, but the will was unattested. It was held that the will was invalidly attested. Oh, so the witnesses signed the envelope. So these scenarios are the ones we need to look out for in the exam. So the witnesses signed the envelope, not the will itself, but it was declared invalidly attested. The term signature is widely interpreted to mean any mark intended by the witness. Now, in the case of in the goods of sparring, there's 1863, a witness attested by writing servant to Mr. Sparring. It was held that the same was a signature, as it was intended to identify the witness as the person attesting. The witness must sign the will for themselves rather than have a third party sign on their behalf. So just know that the witness must be physically present to do the work they are assigned to do, which is to sign. Okay. So let me look at this question. We were looking at Mr. Milo, Mr. Lima. Attestation. The second component we need to consider is whether the will was properly executed and attested. Now, they also quote section 11c that no will shall be valid unless attested by two or more competent witnesses. Section 13(2) provides that in a situation where the witnesses to a will are also beneficiaries, under it, their signatures as witnesses must be countersigned by two additional competent and independent witnesses, otherwise the bequest to them shall fail. So you see, I was right about this, that the beneficiaries, you know why this countersigning is important, because you could just as easily have bequeathed yourself certain properties of the deceased and masquerading. So it's just to be sure that there's more witness. So if you are a beneficiary, you are defeating the purpose of witnessing. But if you go ahead and witness, we still need more witness to witness you. That is so funny. You need more witness to witness you. Oh, okay. So now section 13.2 makes the biggest one attesting witness void where the signature of such witness is not attested. In the okay, let's just look at this section. Okay. So the effect of section 13 is that if the what do you call it, the people, call them people, if the, what are they called, if the beneficiaries, if the beneficiary the spouse who's bequeathed a gift by the deceased was to sign without extra witnesses, the independent ones, they would lose their entitlement to that gift. Okay, this is all to protect any situation where the beneficiary put that gift for herself, Yeah. So there's a requirement on the beneficiary to enlist the attestation of two independent competent witnesses. That was also held in the case of in the matter of estate of George Mbogo Ngari. Excuse me. Now we go presumption. Okay, we go to section 14. witness not disqualified by being executed. So a witness is not disqualified by being, meaning that an executor can also be a witness. Where did I see that? Yeah, so it doesn't disqualify the person from signing. No person, by reason of his being an executor of a will, shall be disqualified as a witness to prove the execution of the will or to prove the validity or invalidity. So, no person, by reason of his being an executor, shall be disqualified as a witness. So, if you are an executor, you are not disqualified. Okay? And the executor can prove the validity or invalidity of a will as a witness. Now, section 15, existing wills, notwithstanding provisions of this part, any written will executed before the commencement of this act shall, whether the testator dies before or after the commencement of this act, be treated as properly executed, if it was executed according to the requirements of the law in office at the date of execution. So, now formal, so this is the transition clause. Section 16, formal validity of other wills. Notwithstanding the provisions of this part, every will, whether of movable or immovable, and whether executed before or after the commencement, shall be treated as properly executed if its execution conformed either at the time of execution or at the time of the testator's death to the law in force. This is also transitional. So, notwithstanding the provisions of this part, every will, whether of movable or immovable property, and whether executed before or after commencement of this act, shall be treated as properly executed if its execution conformed either at the time of execution or at the time to the law in force. So, there's also a compliance clause that it should be you should comply with this act in the state where it was executed, in the state where the property is situated, in the state where the time of the testator's domicile, he was domiciled, or in a state which the testator was a national, either at the time of its execution or on his death, or on his death. Now, revocation, alteration, and revocation. Before we go to revocation and alteration, let me just look at this question we finish it. The question here is this: Section 13(2) provides that in a situation where the witnesses to a will are also beneficiaries, their signatures must be countersigned by two additional competent and independent witnesses, otherwise the bequest to them shall fail. In Mr. Limo's case, his will was witnessed by his wife Nara and his last born son Giotto, who are both beneficiaries under his will. Their signatures were not countersigned Therefore, the bequest to them will fail if we find the will to be valid. We note that only the bequest to Choto and Nara will be invalidated and not the entire will. Now, let me just check this will again. We had Choto was bequeathed some parcels of land and rental apartments. Also, we had Nara is the wife who was given matrimonial home and several parcels of land and some investments. Okay, proceeds now. Then we see the witnesses are Nara, who is the beneficiary, and then Choto, who also is a beneficiary. The other two are not beneficiaries. Now you can wait. Ibrahim and Khan, have they been mentioned? Ibrahim, no. So they are independent. But you see here, why would they? Yeah, it's not countersign. So countersign is, I think, where you have the placement of the sign. One sign like this. Let me just. Oh my God, I don't have anything to write. Just a minute. So where we have, this is someone signs here. Countersign would be I guess, that person. So sign and countersign like this. Where we have the sign here, sign and then countersign. Yeah, I think the positions should be close. That is my understanding at least. So the bequests to them have failed by application of section 13. And then coercion and undue influence. Thirdly, there's the bequest to Mr. Limo's uncle, Chuzo. The question arises as to whether there was coercion exerted on him to make the bequest. Section 7 of the LSA makes any part of a will caused by coercion void. Let me check this section 7. Sometimes you read and you don't understand. Yeah. So, wills caused by fraud, coercion, importunity, or mistake. Yeah, we kind of passed through this one, which is sad because it's important. Wills caused by fraud, coercion, opportunity, or mistake. There is like a whole case law, bag full of case law on this. I don't know why we just assumed that. Yeah, so we have the case of mistake. The knowledge and approval of the testator may be absent because of a mistake on the part of the testator. Okay, the mistake may relate to part or whole of the will. Now, a mistake relating to the whole will render it invalid. A partial mistake may be corrected or otherwise the portion will be revoked. In the goods of hand, that's a case, 1875. The mistake related to the whole of the will. A woman living with the sister prepared two wills in similar terms for their respective execution. By mistake, she executed the will of the sister rather than the will she had prepared for her own. Probate of the will was not granted on the grounds that the woman would not have executed the will had she known that the content of the will she had drawn up for her sister. Then we have the case of Maurice. This is goods of hand, two wheels. Executing the wrong will, okay? In Maurice, 1970, the testatrix made a will, but after some time decided to alter some of its provisions. She instructed an advocate to prepare a codicil to effect the changes. The advocate made a mistake and inserted an erroneous figure. The testatrix executed the codicil, didn't read the contents. Executors brought an action asking to be allowed to use the right figure instead of the wrong one. The court allowed them. So in Morris, it's a typing error, you can say, like a drafting error on the part of the advocates, where a figure other than the one intended was put, and the court allowed for the remedy of the mistake to correct it. Now, Phelan, the testator bought some pre-printed forms from a stationer. He thought that each gift had to be put on a separate form. He made 4 separate gifts on 4 forms. Each form had a stand add revocation clause. He then executed the forms each after the other on the same day. It was argued that only the gift on the last form to be executed was admissible to probate, as the revocation clause on each form revoked the previous form executed, which meant that the testator died intestate in respect of the other gift. It was held that the testator did not know or approve the contents of the wills as far as they related to revocation clauses in each of the 3 wills. The court admitted all 4 wills to probate without the clause. So this was an honest mistake. Now, if the testator does know and approve the content but is mistaken as to the legal effects of the words, they will be considered valid and admissible. Then we have a case of Collins versus Elston. Collins versus Elston. The testatrix was given incorrect information as to the extent to which a revocation clause in her will operated, but she executed the will. It was held that the will was valid and admissible. Then we also have coercion. Let's see, coercion. Says section 7. Coercion. The knowledge or approval may be absent owing to coercion or undue influence being exercised in the testator. Undue influence occurs when a testator is coerced into making a will or some part of it that he does not want to make. Undue influence is proved if it can be shown that the testator was induced or coerced into making disposition that he did not really intend. Okay. Then we have fraud. Let's look at the case. What do you call the case on? Let's look at the case on coercion. We have several. We have Murphy versus Murphy. Murphy versus Murphy. That is East African. The petitioner was obliged but did not demonstrate that the deceased freely and consciously dictated and executed the alleged will. He did not call evidence to exclude the possibility of having unduly influenced the deceased to will his property to him. A distinction should be drawn between undue influence and persuasion. So persuasion is to affection. Okay. Lord Penzance in Hall versus Hall. That is brought out the distinction as follows. Persuasion is not unlawful, but pressure of whatever character, if so exerted as to overpower, okay, the volition without convincing judgment, will constitute undue influence. Though no force is either used, so whole versus whole, it tries to differentiate what is persuasion from undue influence. Undue influence is pressure. And when it's pressure, pressure is not good. It doesn't give you the nice feelings. When someone is pressuring you, overpowering you, those people who have strong will and they overpower you. Do this, just do this, and you're overpowered. And then you can't make your own judgment, because they are so strong on you, like they want you to do it. It doesn't have a nice feeling, but persuasion is to affection. For example, when in Wingrove versus Wingrove, 1885 case, where that a young man was caught with a harlot, who was able to exert much influence over him and induce him to make a will in her favor to the exclusion of his wife, okay, and children. This would not amount to undue influence. So it was persuasion because she was appealing to his affections and it made the man feel good. So it's all about how the person is feeling after that action has been done on them. Whether it is maybe that day she took very good care of him, birthday maybe, just had a quality moment. Yeah, so the man decided what? Maybe I'm not happy at home, and my wife never has time for me or this and that. But again, I would say this is common law, of England, but under the Succession Act of Kenya, if you leave out dependents, the dependents of course, the will be valid, but the dependents can challenge it based on the fact that they are dependents, okay, and they're entitled to having that call to having some reasonable provisions granted to them But still, you see, the court respects a valid will and the intentions of the deceased. Okay. Yeah, so other than just the lover kind of persuasion, there's the familial kind, maybe where you know that this is your kindred, this is your cousin, or this is your uncle, and you've been through a lot together, there's that sentiment, there's that gratitude in case one day they saved your life, or one day they uh, they really were there for you. And if they raise that sentiment, it will be persuasion, not undue influence. Some feelings of pity also, like you say, oh, if you don't leave this for me, I have no one else except you. All my life I've just depended on you, If you leave, I have no one but you, I'll be destitute, something like that. So that, they are all feelings, sentimental feelings. So that does not amount to undue influence. I think the line is how that action is making the person feel. Does the person feel bad and powerless because you're exerting such influence, like you are pressuring them so much that they would rather just give you so you can stop, or is it based on warm feelings of affection, feelings of brotherhood, of gratitude, of pity, feeling sorry. So that is the one for us. Then we have yeah. So coercion can take the forms of actual physical force, like when you hold, like when you see in the movies, the person is holding the hand and sign, just sign here, like that, and the person is old and can't, like, so that is coercion, like you force your hand, okay, and you make them insert some mark there because you prepared the way, recruiting yourself, or you let them, give you everything. That is no, it's not okay. Now, let me just find one case. This James Ngenge Mungai is all over the place. Now, let's see. Under influence was arranged with the mathematics to the eldest son with the necessary suggestion he should write a will and go the family priest to convince the instrument. The objectors also point out that the deceased was living in the house of the son, and therefore the eldest son must have driven the deceased to make the will in the manner. The court was not convinced, as they had previously donated the power of attorney to the son to act on his behalf. The deceased was convinced by a respected citizen, a family priest, to write a will. The advocate will visited the deceased 3 times, for them to live with the eldest son. Okay, so let's just find a case where it was held. We have perfect versus lawless. The deceased left her residual estate to a Roman Catholic priest who was her confessor, and who lived with her and her husband. It was alleged. It was alleged that the confidential relationship between them gave rise to a presumption of undue influence. It was held, however, that there was no positive evidence of undue influence. Okay, so that one won't work. So we have Henry Harden. That is okay. The Times 30 June 1950. Now, Testosterone left property to a spiritualist medium after he allegedly transmitted messages from the other side to her as to what she should do with her property upon death. The messages were dictated to her and resulted in her executing 2 wills that made the medium a substantial beneficiary of her estate. It was heard that the medium had taken control of the mind to the extent that she had written what he wanted rather than the record of her mind. The will was invalidated on the grounds of undue influence. So this is the case Ray Harden. So in section 7 is the statutory provision for coercion, fraud, mistake. Ray Harden. Fraud. When it comes to fraud, knowledge mistake we said was what? Remorse. Okay, so in fraud we say knowledge and approval will also be absent if the testator makes a gift by will or excludes a person from benefit as a result of false statement. So knowledge and approval will be absent if the testator makes a gift by will or excludes a person from benefit as a result of false statements which have been made about their conduct. So we have the estate of Posner. A gift made to a beneficiary who fraudulently misrepresented herself to be the testator's wife was invalidated. So fraud is just malicious. It's lying, is being an imposter. It's all those things, it just doesn't come from a good space. No good intention can result from fraud. No good intention can result from fraud doesn't come from a good place. So in this case of estate of Posner, we see that a gift made to a beneficiary who fraudulently misrepresented to be the wife, the testator's like in which kind of scenario mostly happens in movies. Yeah, all these shocking scenarios, they happen in movies where you masquerade. How do you masquerade as someone's wife, Now, in Pauline Leti Kenyatta, the deceased appointed a woman he described as his wife, the executrix and trustee of his will. He had married the woman under statute while still married under customary law to the first wife. He also stated falsely that he was divorced from his first wife and purported to disinherit her. The Court of Appeal held that the purported statutory marriage was null and void by virtue of the Marriage Act and African Christian Marriage and Divorce Act. Okay, so these acts are repealed by dint of the New Marriage Act. It allows for what do you call for yeah, so I think the Marriage Act 2014 says that you can marry as long as okay, it says that it allows for polygamous marriages where the regime is polygamous, like customary or customary marriage, African customary marriage. But once the person marries in civil marriage, civil Christian marriage, they are barred from marrying others under polygamous regimes. But my question is whether before, if they married customary, and then after they married civil, if it's permissible under the New Marriage Act, I'm not sure. Okay. Okay, so let's look at forgery. Now, forgery, a will also will be void if it is forged. There's a lack of knowledge and approval by the testator of the contents. The forged will is not the will of the testator. The burden of proving forgery lies with the person who alleges. We have a case of Elizabeth Kamene Ndolo. Elizabeth George Matata Ndolo. Now, okay, the Court of Appeal stated that the charge of forgery or fraud is a serious one. The standard of proof required is higher than on a balance of probabilities, but it's not beyond a reasonable doubt. In that matter, the court held that the eyewitness evidence of attesting witnesses was preferable to that of the handwriting expert. Now, in matter of Esther James Muigai, the allegedly forged will was submitted to the Criminal Investigations Department at the request of the objectors. Following a criminal complaint, the document was subjected to an examination. The alleged false signature of the deceased was compared with the deceased's non-signatures. Okay, so that is it on section 7. Now, going back to the question of Mr. Limo, whether there was coercion as provided under section 7, but we need to distinguish between coercion and persuasion. Persuasion is lawful, Wingrove versus Wingrove, where now Tuzo wanted something to remember Mr. Limo, and since Mr. Limo said that he wished to give his uncle the bequest, it is suffice to say that he was persuaded and not coerced. So it is like a memento, like what do you call them? These things. A memento, what do they call? Souvenirs, yeah. So now, Mr. Lim also left a bequest to Charisma, who he said was his spiritual leader. This raises a question of undue influence. To prove undue influence, we must show susceptibility. This can be shown through some form of disability. There must be an opportunity to exercise undue influence. This is proven where there is some sort of confidential relationship, such as between a spiritual guide and his student. There must have been opportunity to exercise and to influence. The record must reveal a suspicious transaction. Now, the circumstances in the case of Julius Wainaina Mwathi versus Beth Mbene Mwathi demonstrate this of undue influence of passion. But we had our own case, the case of the Catholic priest. We also had the Reharden case. Reharden. It was the one with the spiritual guru, the one who said spiritual medium as what she should do with her property. Okay, so Reharden, was the spiritual master. Now Charisma threatened Mr. Leon that he would ensure his soul never got rest, and that he would burn in hell for eternity. Some of these scenarios are very funny. So here is a spiritual master who is threatening that his soul will never get rest, imagine, and that he would burn in hell for eternity. The biggest to him was a result of undue influence and would not stand. The special circumstance. Oh, there was a bequest to the advocate. Let me just read you. Can find some suspicious circumstance. Yeah, I found it. It's under the validity requirements, all things which affect validity. Now, where a person who writes or prepares the will takes a substantial benefit under the will, this will be regarded as suspicious circumstance. So we have several cases here. Uttar versus Atkinson. The proportion, however, is undoubted that if you have to deal with a will in which a person who made it himself takes a large benefit, you ought to be satisfied from evidence calculated to exclude all doubt that the testator not only signed it, but that he knew and approved. I don't know what he's trying to say. So, Tyrell versus Payton. It was said that it would be a suspicious circumstance if the will is written or prepared by a close relative of a substantial beneficiary. In Winter versus Nye, all okay, the testatrix was an elderly woman who had no experience of dealing with money. She placed heavy reliance on the family advocate. She left most of her sizable estate to him. It was held that the circumstances were suspicious. So Winter versus Nye. Okay, so that is what it is. Yes, you can see now how the circumstances are coming up. We have the case of Barry versus Banting. A testator made a will at the home of his solicitor in the solicitor's handwriting and left a quarter of the estate to the solicitor and the rest to friends. Yeah, you can imagine this. Left a quarter of the estate to the advocate and the rest to friends. Testator's son challenged the will on the grounds of suspicious circumstance. It was held that the circumstances were, on the face of it, suspicious, but the suspicion was dispelled by two factors: the fact that the will was executed before two independent witnesses, and the fact that the testator's son was excluded from the will because of his criminal conduct. Oh, okay. So, what case is coming strong here is the Winter versus Nye, where this elderly woman didn't have any knowledge of handling money and left us a substantial amount of her estate to the advocate who was handling her finances. Yeah. Winter versus Nye. Now, that is suspicious. Then we have some cases. Alright, so that is that. Suspicious. Okay, so we can see this the suspiciousness, the suspicion behind the so Mr. Miller bequeathed his advocate, which raised suspicion. Where a person who writes or prepares will takes a substantial benefit, this will be regarded as suspicious circumstance. The significant property left to so you see they also have used the case of Winter versus Nye. The one I told you, the significant property left to the advocate was considered suspicious circumstance. Mr. Lemo's bequest to his advocate will therefore be challenged. Okay, let's see, was there any bequest? Okay, now finally we consider revocation of the will. Mr. Lemo, after hearing his sons speaking ill of him, took the will from his safe where he had kept it, cancelled the bequest to his son. Scoured out the witness signatures, tore up the will and returned it to the safe. Now, was the will revoked? That takes us to section 18, revocation. Before section 18, section 15 is about existing wills, notwithstanding provisions of this part. Any written will executed before the commencement, whether the teacher dies before or after the commencement, be treated as properly executed. It was executing the requirements of the law and force. Formal validity, whether movable and where executed before or after the commencement, shall be judged properly executed and conform to the law and force. Created in the state where the property is situated, or in the state where the time of the testator's death, he was domiciled at the time. Now, section 17, will may be revoked or altered. A will may be revoked or altered by the maker if it is by the maker of it at any time when he is competent. Okay, competent to dispose of his free property by will. So he can revoke or alter any time as long as he is competent. Now, section 18, revocation of will. Save as provided by section 19, no will or codicil or any part thereof shall be revoked otherwise than by another will or codicil declaring an intention to revoke it, or by the burning, tearing, or otherwise destroying of the will within the intention of revoking it by the testator or by some other person at his direction. So we have several actions. Revocation is by another will or codicil, if not by burning, tearing, and destroying the will. Okay, a written will shall not be revoked by an oral will. Okay, that is the section 18. So here they have said, finally we consider revocation of the will. Mr. Lemo, after hearing his son speaking ill of him, took the will from his safe where he had kept it, cancelled the bequest, scoured out the victims' signatures, tore up the will. So we see the act of tearing. Okay. So you can see here clearly. Let's see whether this amounts. Okay. Revocation of a will by destruction requires two components: the actual destruction of the will and intention to revoke. So there should be the actual destruction and with the intention of revoking. This points to the mental capacity and state of mind of the testator. At the time of destruction, the testator must have mental capacity to the same degree as when he created. Of the greatest significance in all the actions of destruction that Mr. Noah engaged in is the scouring through of the witness signatures. We have established by virtue of section 11c of the law of succession that no one shall be valid if it is not attested. Whether actual destruction of part of a will results in the revocation of a whole or part of the will depends on the part actually destroyed. If the destroyed part impinges on the whole will be revoked. For example, the destruction of the part of the will containing the signature. So we have a case here. I don't know in this book where we'll find the signature. Yeah, it's man's goods. So in Ray Morton's goods, the testator signature is completely scarred through. Let me just see, scarred means what? Scarred. is to rub, wash something, or rub or scrub it. Okay, so in Remotion goods, testator's signature was completely scoured through. It was held that this amounted to destruction, and the will was held to have been sufficiently revoked. Okay. By scouring out the signatures of the witnesses, Mr. Limo revoked his will completely. The fact that he then tore the will into tiny pieces and returned it into his safe is irrelevant because the will stood invalidated and revoked at the point where he scoured through the witness signatures. From the above, we can conclude there was no valid will, and Mr. Limo therefore died intestate. His properties will therefore pass according to the rules of intestate. The codicil Nara found a piece of paper next to the torn-up will where Mr. Limo had bequeathed crops and livestock in his Nakuru farm to his sister. He signed the piece of paper himself. A codicil has to be properly executed and attested as per section 10 and 11 of the. Therefore, this bequest will not stand. Okay, intestate succession. Okay. So we can see that a codicil is also supposed to be okay. So will may be revoked, we said, by section 18 by tearing, burning, destroying without will or a codicil. Now, revocation of will by testator's marriage, section 19, a will shall be revoked by the marriage of the maker, but where a will expressed to be made in contemplation of marriage, the specified person shall not be revoked by the marriage so contemplated. Section 20, effect of obliteration, interlineation, or alteration. No obliteration, interlineation, or alteration made in a will after the execution thereof shall have any effect unless the alteration is signed and attested as a written will is required by section 11. Okay. Okay. Okay, let's just stop here for now.